still experienced those in the pandemic, but thank you. I'm Stephanie Thomas, State Representative of the 143rd District, which comprises parts of Norwalk, Wilton, and Westport. And I'm really happy to be joined by Devon Ward. He's the lead attorney in the Marijuana Policy Project's efforts to legalize, regulate, and tax marijuana in Connecticut, New York, New Jersey, and Pennsylvania. I would say that means you've been a great success. His work covers marijuana policy reform efforts in a handful of other states as well. I think everyone watching knows that on July 1st, today, a lot has become legal. So I thought this conversation was a wonderful time to demystify what Connecticut passed, because I've been getting a lot of questions. And Devon, he earned his BA from Howard, his JD from the University of Connecticut School of Law, and was admitted to the bar in all state and federal courts in Connecticut. I hate reading bios, I'm sorry. And in 2019, he was recognized as one of the new leaders in the law, so by the Connecticut Law Tribune. So congratulations. Thank you for taking time out of a very busy schedule to join me tonight. What I was just telling Devon that this has been talked about a lot for many, many years, especially in this district. And what I had heard from most people is like, oh yeah, I support legalization, but they always had an if. And the if has ranged from, if equity issues were addressed, if there was home grow allowed, if the dollars would be spent in a way that was good for the community, if law enforcement could, crack down on unsafe driving, and so on and so on. So before we really dig in, I'm going to ask you a very general question, which is, we've not had legalization all this time. Why do we need it now? Why do we need it? I'll throw it over.
Well, yeah, I want first, Representative Thomas, thank you so much for inviting me. And just for your willingness to engage on this issue. You and I talked a ton throughout the session about this issue, and I know it was one that you considered deeply, and we're weighing all of the various voices you were hearing in your district on this issue. And so, thank you for putting this together on today, the official legalization day here in Connecticut, which has been an exciting and busy day. But to answer your question, I guess how did we get here, and I guess why now? Cannabis prohibition in the United States really picked up in the early 1900s. Prior to that, cannabis was a substance that was promoted in magazines for relieving headaches and all sorts of other ailments. Somewhere, in the early 1900s, a prohibition went into effect for a number of different reasons, and that prohibition, it did have racial undertones with it, where we kind of are in the modern era of cannabis prohibition. Most folks know the war on drugs that was started under President Nixon, and President Nixon's advisors have since admitted that the war on drugs was really a proxy for the federal government to harass and arrest folks who were against the Vietnam War and folks in communities of color. And so it's with that knowledge that, they say when you know better, you do better. And knowing that cannabis prohibition is based in some racial overtones and based in, not actual science in terms of its risk to consumers. Now that we have that knowledge, I think it's imperative on us now to kind of right those wrongs and repeal some of those policies that have had such disastrous effects on our communities, and particularly communities of color. And so while the country and indeed, our state, last summer, we were grappling with the aftermath of the murder of George Floyd and figuring out, how do we as a state move forward and take away some of these tools that have long been used to oppress and harass communities of color. You know, marijuana is, in my experience as an attorney, and it's not my experience alone, but throughout the country, cannabis has been used as the #1 pretextual reason to stop and get into people of color and people in general's persons and their homes and their property. And so, you know, removing prohibition is an issue of fairness, is an issue of racial justice. And also, you know, I think for a lot of folks, it took me a while to kind of grapple that. And one product can, you know, help children with their seizures, make be a substitute for plastic bags, relieve, be used as palliative or pain management medication, and also be used as, you know, a way to enjoy your Friday night, right? All from one product. And I think, you know, a lot of the medicinal properties and just other things we can use cannabis and hemp for, we're just scratching the surface. And so this now gives us the opportunity to kind of pursue what opportunities lie ahead with this plant that's been prohibited and restricted for such a long time.
Thank you for that. That's a really interesting perspective. There is a lot of flexibility in the use. When preparing for this and also during the session, I came across a stat, and I'm going to read it. In 1965, fewer than 50,000 Americans were arrested for marijuana possession or distribution. At about, you know, right after the war on drugs. So by 1973, that number had grown to 400,000. And this particular study only referenced back to 2010. And in 2010, it was 750,000. When I think about the cost to incarcerate someone and, you know, the long-term effects of that on communities, I mean, it just seems mind-boggling.
Yeah, no, absolutely. That was definitely a consideration. The number of folks, arrested for cannabis basically over the past almost 10 years outnumbers all the folks arrested for violent crime combined. And so when you put that into perspective, and to your point, the cost on society, societal cost, and then actual real cost, it's a high cost to pay for a product that it is safer than alcohol.
Yeah, yeah. Or, you know, I do like to joke. I think it's, never mind, I won't go there. Anyway, so let's talk about where we are in Connecticut. So we've become the 19th state to legalize recreational marijuana. And I know you know more than most, at the beginning of the session, we had the governor's bill, Senate Bill 888. The Labor Committee put out a bill, HB 6377. What was signed was SB 1201, which some people consider a mashup of the two with some other things thrown in. So just for the audience, just a quick recap. So possession is legal today for adults aged 21 and over, and they can have up to 1.5 ounces on their person and no more than 5 ounces in their home or locked in a car trunk or glove box. Patients in the medical marijuana program can cultivate up to 6 cannabis plants, 3 mature, 3 immature, indoors, in their homes, beginning October 1st of this year.
Right.
All adults will be able to do that July 1st, 2023. So 2 years from now. So don't get your plants, don't get too excited. And households will have a maximum of 12 plants. And those are the very basic details. But there are many, many other components in this bill. So I'm going to dive into some of them.
Sure.
One thing that came up a lot this session, and I've come to realize living in Connecticut for almost a decade now, that communities really want local control over certain issues that affect their residents. And that makes perfect sense. And I think it's a good thing. So what I liked about this bill from the outset was that local officials can decide on the number and location of retailers, who will sell through their local zoning regulations. And they can also decide about public spaces like town parks, beaches, sidewalks, etc. And although I was happy to see that, it also raised a red flag for me. Like I started thinking, is this going to be the thing that happens in all the cities that the surrounding towns can avail themselves of without needing to have a retailer in their community? And I don't know if that's good or bad, but I thought, I was reading some of the comparisons to other states, and I thought Montana, for example, had a really interesting model where a town could not ban a retailer if the majority of their voters had supported the ballot initiative about it. And I thought that was really interesting. It's obviously not what we did here. So I'm just curious if you have any thoughts on how this plays out in real life, any cautionary tales, anything? Is it great, or should we be aware
Well,
of something? Yeah.
I think the way the bill is written in Connecticut is really thoughtful, and it recognizes our history of home rule, right? We love our 169 towns here in the state of Connecticut, and this bill doesn't interfere with localities' authority to regulate what goes on in their town. So if you are a municipality that does not want a cannabis establishment within your borders, that is your prerogative, and you are free to do that. The downside of that is the only thing you'll really be missing out on is the revenue, because the residents of your town will still be able to consume. You can't restrict residents in your town from receiving cannabis, so delivery services can still deliver into the town. So really, for towns who do decide that, a cannabis establishment within their borders is not for them, that's certainly their prerogative. But in reality, the only thing that they'll be able to stop is the flow of tax dollars from that cannabis establishment entering their town's coffers. And so, but that's their decision to make, and within the bill is also provisions that allows for the local zoning board to set time, place, and manner restrictions. So, if for a local town who really values the character of their town, you're not going to get some big box cannabis shop moving into Main Street and, putting up bright lights that aren't consistent with the character of the town. The zoning board will still regulate signage, regulate where these places can be sited within the town, what hours they can operate. The bill also allows for a town to bill up to $50,000 for public safety when these establishments do open up in the town. And so, I think the bill really gave a nod to municipalities. The other big consideration is these things called community host agreements. Community host agreements are typically payments that cannabis businesses make to whatever towns that they're cited in. We ban those here in Connecticut because they've proven to be problematic in a number of different other states. The mayor of Fall River, Massachusetts recently was convicted for essentially extortion of cannabis businesses. And we found that this community host agreement arrangement was rife with corruption, where essentially, you had local officials saying, well, if you pay me $50,000, we'll approve the zoning for your cannabis business to be here. And the other town next door would say, well, you only have to pay us $25,000. And so we eliminated that altogether, where there's no community host agreements, but we did allow municipalities who do have cannabis businesses in their borders to levy up to a 3% tax. And that tax, in terms of the revenue has to be used for very specific items, streetscapes, civic engagement. So there's some discretion, but that money can't be used to increase police overtime or to buy a new trash truck or something like that, right? I think Connecticut's bill is struck a good balance for the state, in that it does give municipalities here pretty wide discretion. That's a normal feature, even comparing Connecticut to New York, which your district is very close to. New York, they actually have a provision in their bill that actually allows municipalities, again by referendum, by vote, to decide if they want to have a cannabis establishment in their borders, and they have to make that decision by a certain amount of time. But because Connecticut legalized through the legislature, it's really up to local officials and local voters to make their voice heard on what they think is the most appropriate way to move forward for cannabis in their town.
That's great. And I wasn't going to touch on revenue yet, but I'm glad you brought it up. And just to uh, make sure I have it all correct, towns can assess a $50,000 fee. And what I was not clear about, actually, I can't remember the final version, is that per retailer?
It's per establishment, correct?
Okay, and retail outlets right now are limited to no more than one shop per 25,000 residents.
Correct.
Municipalities can assess a 3% tax.
Correct.
And they can also implement fines, as I recall,
Yeah.
which
Yep.
could also lead to additional income. I wanted to talk about something that is born out of a private story that will now be very public. And it pertains to packaging and labeling standards. So about 6 years ago, like most people won't believe this, but I wanted to try marijuana because I never had. And I flew out to Colorado because goodness knows I can't do something illegal. So I flew out to Colorado with some friends, went to a dispensary, and ended up getting some gummies. And I ate one. And about an hour later, I was like, I don't feel anything. I'm going to eat another one. So anyone who is familiar with these products will know that that was not a good idea. I should have probably tacked on another 20 minutes, but I had no idea like how much was too much. So I have a couple of questions related to that. There are a lot of restrictions in this bill about where people can smoke cannabis. And I'm curious if you think that pushes people to the usage of edibles, and like, has that been borne out anywhere? But also, is misdosing a problem? And are packaging and labeling requirements stronger to help offset that? Or I would just love any thoughts you have on that topic.
Yeah, I think one, to answer your first question, I don't think the bill is encouraging one form of consumption over the other. I think the bill it tries to find it tries to make cannabis use consistent with other smoking. So in the bill it's not only does it prohibit smoking cannabis in the same places that you're prohibited from smoking cigarettes, it actually expands the law for smoking across the board. This thing that we have in Connecticut called the Clean Indoor Air Act, it expands that starting October 1st. You can't smoke anything, vaping, cigarettes, cannabis, none of it can be smoked within 25 feet of an open airway, patio. It also expands the Clean Indoor Air Act to any business. So if you're any business in the state of Connecticut, you can't allow smoking inside. Before if you had less than 5 employees, you could pretty much set your own rules. So it has those protections in there, and then it has the provision that if you're a town over the size of 50,000, you have to designate a smoking area basically in your town, because the thinking with that is for large towns like Hartford, where I live, or New Haven or Waterbury, or Bridgeport or Stamford, you don't want folks just walking around the town green smoking cannabis. And so the idea is for towns that are large like that, you do want a designated smoking area where folks who can who choose to consume can consume. Also with those larger cities too, you have a lot of folks who live in multi-unit housing where they may not be able to smoke inside their house, and so you want to provide an opportunity for folks who do smoke to be able to smoke somewhere in a reasonable fashion that doesn't disturb the peaceful enjoyment of other residents. In terms of labeling and consumption, there are really rigorous protections in the bill. So first of all, Connecticut's bill has a 30% potency cap. Basically, there can't be any products that are over 30% potency THC, except if they're for medical patients who sometimes do require higher THC potency. But in terms of the labeling, that's one of the benefits that Connecticut has as being the 19th state to legalize. Is we can look at Colorado and Washington, which were among the first states to legalize, and learn some of the lessons learned. And to be candid with you, when Colorado rolled out, they had these 100 milligram candy bars that folks were consuming and ending up in the ER. And so we're not going to have that here in Connecticut. For one, it requires that the serving sizes be broken down to 5 milligrams of THC. So if you purchase a candy bar, it'll be split up into kind of like 5 milligram tablets. The other thing about the labeling on the products, some of the products that you may see out west in California or Colorado absolutely will not be allowed here in Connecticut in terms of labeling. So there's not going to be any cartoons, no designs that appeal to children. So you're not going to see, your Sour Patch Kids that are actually edibles or Skittles that are actually edibles. There will be none of that in the state of Connecticut. And actually all of the packaging has to be child resistant. So it has to have special child resistant labeling. And it also has to have, I think the edibles actually have to have a stamp on it as well so folks can identify when they're looking at it that this is a THC gummy bear versus a regular gummy bear. And so the labeling and the package standards here are benefiting from, the fact that Connecticut is the 19th state and being able to look at some of the lessons learned in other states and really adopt those best practices to ensure that, public safety and that adults are the ones consuming it. And when adults consume it, they are being made aware of the health effects and the potency.
So let's talk about underage use, because I think for people on any side of the issue, I heard it talked about a lot. People who were very much in favor of this legislation, as well as people who were against. I think everyone agrees we don't want it in the hands of kids. So a couple of things struck my attention, and one had to do with the penalties. Some of the penalties for adults are retail establishments seem higher than what I recall from like something like selling alcohol to a minor. The penalties for the young people themselves seem probably middle of the field compared to some of the other states in terms of fees and whatnot. But that's just my anecdotal evidence. I'd love to hear a little bit about how we stack up to really discourage, in addition to obviously advertising and how the product looks, but in terms of the law.
Yeah, I mean, so there was really a focus on trying to parity for underage use. There's really a focus on trying to parity that penalty with alcohol, right? And we don't want the penalties to be any stiffer for folks underage using alcohol versus cannabis. And so there was really a lot of thought in trying to pair the laws to that. But I think when you're talking about underage use, you have to be distinct too with how, what age, because, when you're talking about adult use, you're talking about folks over 21. So you have that range where folks are between the age of 18 and 20. So they're legally adults, but they're not yet able to consume. And so for that, the penalties, first offense of possession of less than 5 ounces, it's a $50 fine. And the fine can be waived if an individual says essentially they're broke. They can perform community service. And for a second offense, it's a $150 fine. And again, you're allowed to perform community service. But the interesting part, the unique part that Connecticut added to their bill is that for folks between the age of 18 and 20, they make them sign an acknowledgement acknowledging the negative health effects of cannabis on young folks. And it also, similar to alcohol, where if you get caught with alcohol as underage in between, the ages of 18 and 20, they suspend your driver's license as well. And so that's another deterrent for young folks as well. But I thought the health acknowledgement piece was really important because that's something I hadn't seen in other states. Getting folks to acknowledge that, that you're underage and that this product could be harmful to your development, and making folks sign that, I think is a powerful thing because it provides them not only with the deterrent, but some information that may inform their choices moving forward. And then when you're talking about folks that are under the age of 18, it's really a tough question of you want to enforce it, you want to prevent it, but you don't want to criminalize young people and essentially blemish their record with a scarlet letter that's going to follow them for the rest of their lives, at such a young age. And so for the first offense, for someone under the age of 18, it's a written warning and possible referral to Youth Services Bureau, which is almost like juvenile court. Second offense is a mandatory referral to Youth Service Bureau. Third offense is you're adjudicated in juvenile court. if you have a driver's license, also your driver's license is suspended for 60 days. If you're found in possession and convicted of possessing any amount of cannabis. And so, Connecticut, comparing it to New Jersey and New York, I think, in terms of the health acknowledgement, the suspension of the licenses, and the penalties, in New Jersey, there really aren't many penalties aside from that they make them sign an acknowledgement as well. It's not a health acknowledgement. It's more so them acknowledging that, they understand it's a crime. They understand it's a crime for minors to possess, but they're not involved in the criminal justice system at all. There's also really no way to track it, which was a big point of contention in New Jersey. But Connecticut's bill, by kind of creating this on-ramp for folks under the age 18 to get involved with some services, and then for folks in that 18 to 20 age group to at least be advised of the negative health effects, I think is a nice balance to strike. And so, and the other thing I want to say too is, this bill isn't perfect, right? And some things we had to get right, and some things we had to kind of put the structure and bones on it the first year. But I imagine we're going to be doing cannabis laws in the state of Connecticut for the next decade. And so, we'll gather more data on how this looks in about a year or two. I do want to say too that this also directs the Department of Public Health to do a study on high school usage. That's in the bill too. So we're going to get some data in a couple of years, and we'll be able to tweak our laws to right size it for the state of Connecticut. But preventing underage use is really paramount. I think for lawmakers and for everybody in the state. No one wants to see folks under the age of 21 using this product.
Don't worry, we'll talk about tweaks and your wish list later. Also, I hadn't realized how many prohibitions were built in terms of advertising. No television, radio, internet, print, billboard ads, unless there's evidence that, I think it's more than 90% of the audience is over or 21 and over. Correct. How does that typically work in real life on the ground? Are these on the internet, I know if you go to a liquor company, for example, you just have to enter your birthday, which of course you could enter anything. But have other states had similar provisions, and how does it work on the ground?
Yeah, no, that's a new, unique thing to Connecticut. It was something we're going to see how it plays out. It's a novel kind of concept. It was one that I disfavored because I thought enforcement was going to be really tough. But essentially what it means is, unless you can guarantee that, less than 10% of your audience is minors, you can't advertise there. And so, like you said, if you're going to a cannabis site, you have to enter your age. But I think more so the thinking was for, things, the billboards you see, the television advertisements, the radio advertisements, those are banned. If cannabis companies cannot advertise by any of those methods unless they can certify that with some type of data to show that, less than 10% of the audience is minors. And so, that's a novel provision, I'm interested to see how it works out. I hope it does not lead to some litigation with First Amendment.
I feel like it could, but
it's an issue I've raised with lawmakers as well, and equal enforcement too, because you have companies here from Massachusetts that are already advertising on our highways. And so it'll be interesting to see how that's enforced, but that is in the bill. That's contemplated that at least any cannabis company that is licensed out of Connecticut will not be able to advertise by these wide-reaching means, television, radio, even print advertising, unless they can certify that only folks over 90% of the audience, as you said, is over the age of 21. And so that's a unique concept. It's not in any other state, and so I'm interested to see how it plays out here in Connecticut.
Interesting. You just said something about Massachusetts, which reminded me, and I actually don't know if it survived in 1201, but I know some of the earlier versions had limits on retail licenses going to Connecticut companies or a majority interest of, you had to be 5 years in Connecticut. Is that what survived in the final bill?
In terms of ownership?
Yeah.
Well, so yeah.
And we'll talk about equity next.
Sure.
But yeah.
But yeah, I mean, you do have to be a Connecticut resident, at least in the initial years, to apply for a license, or have, you know, someone who does have an ownership interest who is a Connecticut resident to apply for a license here in Connecticut.
I think that's great. Do other states have similar provisions?
They do, and you know, New York has a similar provision. New Jersey has a similar provision as well. So that's typical when the market's starting out. That they at least have some type of partner or interest that is someone who is a bona fide resident of the state.
Great. And we have a couple of questions on Facebook, and I want to tell those people we are going to get to those subjects. But first, I do want to make sure we reserve time to talk about equity, because that was, I was telling Devon earlier, a lot of the emails I received from constituents said, look, I really support this, but not if we don't get the equity piece right. And it has a lot of equity components. So I'm actually going to ask you, I had a quote I wanted to read. So Senator Gary Winfield was quoted, I think in the one of the papers, and he said, "What makes the bill amazing is that it incorporated not only where we're going, but where we've been, and making sure we deal with the things that impact communities because of where we've been." And that circles back to what we talked about earlier. So in terms of the equity piece, in your opinion, do you share Gary's opinion? Is this bill amazing?
Well, you know, look,
What do you think we got right?
so yeah, I mean, I think we got a lot right. I think largely, you know, this bill is one of the strongest bills in terms of equity in the country. Now, it's not perfect, but it is one of the strongest, and I'll tell you why. In the bill, it spells out that 50% of the licenses are going to be dedicated to equity applicants. So just to use round numbers, if the state says we're going to have an additional 50 retailers, 25 of those retailer slots have to be set aside for equity applicants. To have that in the bill is huge. New York has a goal in their statute. Theirs is a goal of 50%, but it's not mandated by statute. Connecticut's is. In New Jersey, their statute is 40%. And so, you know, when you're looking at what Connecticut got in terms of 50%, it's almost a 1-to-1 licensing for equity applicants. There are not many states that have that written into statute. And so just that alone, then when you're, you know, I like to talk about equity and kind of two buckets: front end equity and back end equity. And the front end equity is the market opportunities, which I just talked about in terms of 50% of the licenses being set aside. But the one thing I want to talk about that I didn't address is exactly what is an equity applicant. And so an equity applicant is a cannabis establishment that is 65% owned and controlled by one or more individuals who, one, have a median income for the last 3 years that was no more than triple the state's median income. So it's essentially $230,000 or so, basically. So if you you can't have a median income over the past 3 years of more than $230K. Secondly, you have to have lived in a disproportionately impacted area for 5 of the past 10 years or 9 of the first 17 years of life. And I think that is what Senator Winfield was referencing when he was talking about, you know, giving a nod to where we've been and where you're going. This bill essentially says, you know, you'll get priority in licensing if you grew up in a neighborhood that was disproportionately impacted by the war on drugs. And you know, God bless you if you've advanced and made it out of those neighborhoods. So we're still going to recognize that you grew up there. Or if you've lived there 5 out of the past 10 years, you're currently living there. We're going to give you priority in terms of being able to have an opportunity in this new marketplace. And so those are, that is what it means to be an equity applicant, those two or three rather features. And so, and also I just want to define a disproportionately impacted area. It's a census tract that has an employment rate over 10% or that has a high rate of arrest over the past 40 years. And so those qualifiers are going to be basically, if someone, you know, wants to be a social equity applicant and get the priority licensing, they'll have to be designated that by the Social Equity Council, which the legislature and the governor's office is in the process of seating. And so moving from the front end equity to the back end equity, and the back end equity, you know, I said before, is more so the revenue. what the bill does is it dedicates 60% of the revenue in year 3 to social equity and innovation. That then moves up to 65% in year 5, I believe. Give me 1 second. I don't want to be misquoted. Yes, it moves up to 65% in the year 2026. And then it increases again to 75% of the revenue in 2028. So again, so that's 60% of the revenues to start out with, 65% of the revenue by year 5, and then 75% of the revenue from the excise tax going towards equity efforts. And so comparing that to other states, New Jersey's is around 40% as well in terms of revenue. New York has this weird kind of split where they do 40, 40, and 20. But there aren't any other states that are designating 75% of the revenue towards equity efforts. And so that's why a lot of folks around the country are saying this is one of the strongest bills on equity, is because it's taking the bulk of those excise tax revenue funds and redirecting them to social equity efforts. And when I say social equity efforts, I mean low interest loans or grants to entrepreneurs in this industry. It could be used on civic engagement. It could be used to help folks who are reentering society. It could be helped, for grants or grants to nonprofits that do all sorts of work in communities. And all those uses are going to be sorted out by the Social Equity Council in terms of how they're going to best spend that revenue once it is collected and generated.
No, thank you for that. I've heard, like you said, it's not perfect, but I know I had an opportunity to speak with a lot of people who were part of the original legislation in Colorado and some other states as well. And they said they wish they had thought about it. They had thought to include it because it's much more difficult later. So they have also applauded our efforts. Because you touched upon it, someone on Facebook had asked about where the taxes are going. So as we talked about, there's the 3% tax to the municipality, there's the regular sales tax. There's a tax based on the THC content. And essentially there is, so the social equity piece gets the schedule you just talked about. My recollection are, I think I have it right, 25% goes to prevention and treatment programs.
Yeah.
And then the remainder goes to the general fund. Am I missing anything there?
Yeah, so I just wanted, there's a couple of taxes that are levied on cannabis. There's the potency tax, which you talked about. That's the excise tax. There's still the standard state sales tax, which is 6.3. Yeah. And then you also have the local municipality tax that it could be up to 3% as well. So when you're talking about the tax that's going to be kind of broken up by percentages, we're talking about the excise tax, the potency-based tax that's going to be placed on products at the point of sale. And that tax is, for the first couple of years, it's 60% towards equity efforts, 25% towards prevention and recovery services, and then the remaining 15% to the general fund. And then that scale moves more and more away from giving money to the general fund till eventually it's zeroed out at no money to the general fund, 75% to equity efforts, 25% towards prevention and recovery services. And that's for the excise tax, because you got to remember, at the end of the day, the state is always going to collect that 6.3 sales tax. So the state's not, the state's coffers aren't being completely empty either. They're getting to collect the 6%.
And the towns are getting the 3%.
Correct.
And since we're talking about money, one other thing that most people didn't realize, so the medical marijuana companies can transfer to recreational marijuana, but they have to pay an extra $500,000. Is that right?
It depends
Not extra, but to do that,
they have to pay a fee.
Need to, Yeah,
they have to pay a fee, and the fees are fairly large. So in Connecticut, we have 4 cultivators, we have 18 retailers. And the way the bill is essentially designed is that aside from the equity applicants, the medical folks can pay a fee to be able to sell to medical and adult use customers. For a cultivator to be able to supply cannabis for adult use retailers, they have to pay a fee of $3 million. For a retailer to be able to sell to medical customers and adult use customers, they have to pay a fee of $1 million. Both of those fees can be cut in half if those existing operators, they form what's called a equity joint venture. So they partner with an equity applicant and they maintain this partnership with this equity applicant for 7 years. They're allowed to pay a half price fee if they do that. But the point is that they're still going to have to pay either in the case of a retailer, $500,000, in the case of a cultivator, $1.5 million. And those fees are directed back into the social equity and innovation fund that's used for community reinvestment. It's used for helping out entrepreneurs in this space or entrepreneurs from these disproportionately impacted communities. But it's put into this fund for the Social Equity Council to then figure out how they're going to best use to support disproportionately impacted communities.
And I see Ileana has a question on Facebook about tax money going towards education. And I think if you mean the education system, the answer is no. But in terms of prevention, education about not like what marijuana is or not using it, substance abuse programs, there will be money going to that type of work.
Correct.
Yeah, if you want to add anything.
No. I mean, you explained it exactly how it is. That's exactly right. I mean, there may be some of the general fund revenue directed towards educational efforts. When you think about the concept of money's fungible, right? And so
once it's in the general fund, it
right.
can be used for any purpose that the state typically, yeah.
Exactly. So you could make a claim that the 15% that's going to the general fund, could be used for education, and it very well may be. But and is it any earmarked specifically for education? No, not yet. But that's not a possibility. That's foreclosed. Some states have done that. Colorado, for instance, they built an entire school. One town built an entire school off of cannabis revenue, and so it's possible. But that's not earmarked in the bill.
And there is another question. I'll take it now. Let's see. So basically it's asking why HomeGrow for non-medical patients is being put off for another 2 years. I think I know the answer, but you probably know more about it than I do.
I mean, the conversation around HomeGrow was a tough one to have this session. I want to say first, MPP is absolutely in support of HomeGrow.
I mean, I'm surprised actually there is any HomeGrow included based on some of the conversations that were being had in January and February.
Right. And so, I'm personally in favor of HomeGrow. My organization's in favor of HomeGrow. The question is whether or not it's politically feasible. And there are a number of residents who would like it. But when we were trying to get the bill across the finish line, one of the number one things you hear about legalization is safety. And so from this product going from a product that was illegal to the prospect of, someone being able to grow it next door to you in your backyard, politically, it was a tough sell for some legislators. And so what you see reflected in the bill is really a compromise where folks who are interested in cultivating their own cannabis for their own personal use at home will be given that opportunity in a couple of years. But I think the 2-year mark, it really allows the Department of Consumer Protection that's going to be regulating this to really ramp up. They have a ton of work to do in terms of just standing up the market before you even get into regulating your next door neighbor growing this, or everybody being able to grow it. And so the balance that struck in the bill kind of recognizes the realities of governance, right? And that there's only so many people to do so many things. And so step one for DCP is going to be standing up this new regulated market, then allowing medical patients to be able to grow their own. And that was even I think a nice on-ramp as well to HomeGrow, because the medical folks, they're licensed. DCP has a track of where these folks live, so they can obviously more closely regulate it, and then transitioning to all adults being able to grow their own, which is very similar to what's in New York's bill. Is New York has a nod to HomeGrow as well. They don't start it off immediately, but there's a nod to it in the bill and saying that the state is going to transition to it in a couple of years. It's not in New Jersey's bill, and so but it is in a number of other states. It's in Massachusetts, it's in Illinois, it's in Michigan. And so, Connecticut's getting there, but this is a brand new program, and it's going to take some time to ramp up. And so I think that's the compromise you see struck in the bill.
And also, there seemed to be a compromise. I remember a lot of heated discussions around indoors versus outdoors, and we landed indoor only. Can you talk a little bit about how that compares, and good, bad? What do
you that was something we didn't support either. We disfavored, I like to say we disfavored, not that we didn't support it, but we disfavored it. Connecticut, I think folks have to remember, right? Connecticut is a state that just started allowing folks to purchase liquor on Sundays less than a decade ago, right? And we're a tightly regulated state, and folks simply are the political temperature is folks are not necessarily comfortable with folks being able to grow cannabis outdoors. And when you're growing indoors, you can obviously more closely regulate it, right? You can ensure that a kid doesn't sneak in the middle of the night and steal off a stalk of a piece of trim off your branch, and you can more closely control and regulate an indoor grow than you can an outdoor grow. But that's not to say we won't get there. I think, like I said, this was something we had to do to get it across the finish line, but we'll obviously be doing cannabis bills for quite some time, but we'd like to see outdoor grows permitted as well.
And another sort of term in this field is about mature plants, immature. We landed here in Connecticut on 6, 3 mature, 3 immature. I know some states go up to 12, some states have slightly lower, as I recall. Where do we stack up in terms of the 18 other states? And can you talk a little bit about mature and immature? What is it, Devon?
A mature plant is a fully grown plant that's yielding buds. An immature plant is a plant that it just looks like a regular plant. It doesn't have mature cannabis. You can't take anything off of it and smoke it. And so that's really the difference. You're allowed to have 3 mature plants, which are the ones that actually produce the buds, versus 3 immature plants that are the ones that are still developing. And so comparing it to other states in terms of HomeGrow, give me a second. I'm just looking at my comparison document.
I may have something too. Who has like Alaska 12? Okay. Oh no, 6 and 12.
Got it. So for Virginia, it's up to 4 cannabis plants starting today. Virginia just legalized today too. Their legalization bill just went into effect. And Vermont, it's 2 mature and 4 immature plants. In South Dakota, 3 plants if there's no retail stores in the local jurisdiction. In Oregon, it's 4 plants. In New York, it is 3 mature, 3 immature, just like Connecticut. In New Mexico, it's 6 mature and 6 immature with 12 per household. New Jersey, again, there's no home cultivation in New Jersey. In Nevada, it's 6 plants in a secure location, no more than 12 per household. Montana, 2 mature plants and 2 seedlings. Michigan is 12 plants, no more than 12 plants on anyone's premise. In Massachusetts, it's up to 6 plants per person, no more than 12 per household. Maine is 3 plants flowering, 12 plants immature. Illinois is not allowed except for medical. Colorado has 6 plants. You're allowed up to 3 flowering. California, 6 plants. Arizona, 6 plants. Alaska, 6 plants. So
we're about and it seems like everyone has maxed out as 12 at 12, so that a household with 6 adults, for example, can't just have an entire shop.
And off of 1 plant, you can yield a ton of cannabis. And so, if you're interested in cultivating more than 3 plants, or more than 6 plants rather, I'd advise you to go out and get a micro cultivator license, because that's a lot of cannabis.
Fair enough. We are getting to the end of our time, so I promised that we would cover, and we will. I think House Majority Leader Rojas said the same thing. He's like, any major bill, any major law that's very complicated, we're going to see legislation around this for decades to come. So if you could fix anything, change anything, anything we should, anything on your radar to watch to see how it works here in Connecticut, since we have done some things differently, I'll give you the last word.
I'm interested to see how the equity joint ventures play out, whether or not the folks here in the market to even use that. They may just feel comfortable just paying the fee and not having to partner with a social equity applicant. I'm interested to see if any business takes up those opportunities. I'd like to see no caps on licenses. Basically, there to be no caps on licenses, just like we do them for liquor or for other retailers. Basically, if you're able to, if the market dictates that you can have one, you can have one. But I'd specifically like to see no caps for micro cultivators. We've seen in other states where they do roll out adult use that there's usually an initial lack of supply. And so, as opposed to licensing one of these big behemoth cultivators, I'd love to see some of the smaller guys in our state get a chance to at the market. And so I'd like to see no caps on the micro cultivator license.
And what's the official definition of a micro? I mean, I think of it as like a craft brewery or something.
Exactly. It's a grow that's under 15,000 square feet of canopy space. So it has to be under 15,000 square feet. If you're more than that, you're considered one of the big guys. You're officially a cultivator. But micro cultivator is anything. It's as low as 2,000 square feet of canopy space, all the way up to 15,000 square feet of canopy space, and that's what makes you a micro guy. But the cool part about the micro cultivator license type is it's the only license type that's vertically integrated, which allows you to go all the way from cultivating the product to delivering it to a consumer. So micro cultivators, they can't have retail shops, but they can deliver directly to consumers, which makes it a really interesting license type for folks who are, like you said, your craft brew kind of comparison, kind of a craft brewery of cannabis, that they'll be allowed to kind of try out different things in the market and create little niche products and niche strands and see how they play out. But to me, those are the real things I'm looking at. I would love to, again, just to see this be an open license period, but I think, there's going to be a period where we ramp up and we're going to learn a lot over the next 2 or 3 years here.
And that made me think of one more question, which is, how has this played out in other states? Has it been totally taken over by the huge companies, or are we starting to see, especially in places that have had it for a long time, are we seeing like these micro cultivators carving out like a more interesting niche, or, setting up their dispensary in a certain way to appeal to, a more niche consumer? How is it playing out?
The reality is we still live in America and capitalism is still real. And so, there are a couple of, what we call multi-state operators. There's a couple of larger companies that are into the space. And it's also kind of a recognition of where the market is. 10 years ago, or we're approaching the 10-year anniversary of Colorado legalizing, but 10 years ago, the conversation around social equity and diversity in the industry was not even a conversation that was being had. And so, that feature in terms of diversity and in terms of social equity is a conversation that's probably started to take place over the last 4 or 5 years. And so we're just now starting to see kind of the effects of that. But the equity programs in Massachusetts hasn't rolled out very smoothly. There's been a ton of litigation. Same thing with Illinois. Illinois' equity efforts have been stalled. They just got their first round of folks licensed in Illinois. Michigan is tied up in a bit of litigation as well. I'm praying we don't see that here in Connecticut either, because litigation will certainly slow down equity folks from getting their license, and in the interim, the medical guys will continue to make a ton of money. And so we're hoping those issues don't arise here. But to answer your question, predominantly the owners of cannabis companies throughout the United States are white men. There is a greater focus within the past 5 years of trying to diversify the industry and trying to give opportunities to folks who come from these disproportionately impacted communities that were harmed by the war on drugs.
Well, our time is coming to an end. I so thank you for joining us. This is an issue we have heard about for many years. I think we will continue to hear about for many years. Whether you are for or against, it is signed into law. I advise everybody to do what I always advise: make your voice heard, write to your state legislators, your local municipalities will have a lot of control of what, your zoning commission, as a former commissioner, a lot of these decisions about like sidewalks and signage, all the things we talked about will be made there. So these public meetings matter. Get involved. It's the best way to make sure your community stays as you would like it. So thank you again. Thanks for anyone watching on Facebook. Thank you, Devon. I really appreciate it. You are such an expert in all of this, and I always enjoy speaking with you. I'm sure I'll call you in the months and years to come. And have a good night, everyone.
Thank you.
And thank you, Brittany and Giovanni, for putting this all together. Bye-bye.
Thank you. Have a good one.
Thanks.